It is my pleasure to introduce the next panel, which is on Caraco Pharmaceutical v. Novo Nordisk. And moderating this panel is Dr. David Clough. David Clough is a partner in Morgan, Lewis & Bockius's litigation and IP practices. Dr. Clough received his BS from the University of Arizona, a PhD in microbiology from the Medical College of Wisconsin, and a JD from Chicago-Kent. Prior to attending law school, Dr. Clough served on the faculties at the University of Illinois at Chicago College of Medicine and the Northwestern University Medical School. He also was a postdoctoral fellow at Harvard Medical School. Thank you, Dr. Clough.
Thank you. I'd like to introduce my fellow panelists. To my left is Stephen Outen, and to his left, Mr. Jose Rivera. Mr. Outen is a member of the intellectual property practice group at Cozen O'Connor's Chicago office. At least he has been for the last 10 days.
Right? Mm-hmm. A full 10 days back at a private practice.
Right. Previously, he was the vice president and head of intellectual property for North America of Sandoz, Inc., the generic pharmaceutical division of Novartis. Mr. Outen graduated with a BS in chemistry from the University of Illinois at Urbana-Champaign and earned his JD, like me, from the IIT Chicago-Kent College of Law.
In fact, I had my first class in this room 18 years ago.
Mr. Rivera is the divisional vice president and associate general counsel intellectual property for Abbott Laboratories, and he oversees Abbott's intellectual property litigation department, patent and trademark department, and IP strategy department. He joined Abbott in 1996 as a litigation attorney, and since he has served as the division vice president, divisional vice president for litigation, and divisional vice president for intellectual property litigation. Mr. Rivera received his BA in economics from Boston College and his JD from Harvard Law School. I'd like to start out here with a brief little syllabus of the case. As I'm sure some of you are aware, these kinds of cases are just enmeshed in arcane statutory interpretation and numbers, and I'm going to try to keep it as simple and as far away from that as I can, with still maintaining the gist of what this case was really all about. The FDA maintains a list of approved drug treatment patents that cover treatments, and it also contains use codes, which are supposed to summarize the patent, the scope of the patent that covers the approved treatment. I should mention here that the FDA does not review entries into this what is called the Orange Book, and it's managed primarily by manufacturers and patentees who regularly provide updates such as new patent listings, delistings, and amendment to use codes. There is a benefit, although it's not required, there is a benefit to listing a patent in the Orange Book because it gives the patentee constructive standing to sue based on the generic company's filing of an ANDA, which is an abbreviated new drug application, which cannot be approved if the proposed use code overlaps, with the proposed use overlaps with the use code listed in the Orange Book. In fact, the ANDA cannot be approved if there is any overlap with the use code. Now, there are ways to get around that, and we'll probably talk a little bit about them here. For example, the generic manufacturer can file what's called a Section 8 carve-out, which effectively carves out the patented use out of their approved use. To get on to the specific facts of this case, Repaglamide, an anti-diabetes drug, has 3 approved uses. Novo's listed patent covers one of those uses, which was reflected in its original use code. Based on the limitations in that use code, Caraco filed an ANDA requesting permission to sell the drug for use in the 2 unpatented methods. Nova then came along and changed its use code so that it covered the unpatented uses, and then sued Caraco. In response, Caraco filed a counterclaim to force Novo to amend its use code under Section 355 of the Hatch-Waxman Act, which allows the generic to assert a counterclaim seeking an order requiring that the brand correct or delete the use code on the ground that the patent does not claim an approved or the approved use. An approved use, the approved use is really the nub of the issue here. The district court granted the counterclaim and issued an injunction ordering Novo to change the code. Novo appealed to the Federal Circuit, and the Federal Circuit reversed on the ground that Caraco could only assert a counterclaim if the patent didn't claim any FDA-approved uses. It didn't matter whether it was a use for which the generic was not seeking approval for. The case was then granted cert in a unanimous decision by Justice Kagan. The court overturned the Federal Circuit, holding that a generic drug manufacturer may employ the counterclaim provision to force the correction of a use code that inaccurately describes the brand's patent as covering a particular method of using a drug, even if other approved uses are covered under the patent. The court further held that a use code is a kind of patent information that a counterclaim may seek to correct or delete. So what this case came down to was the statutory interpretation of the word and the statutory interpretation of the phrase patent information. Given that, I'd like to get on to the questions by starting out with the fact that the Federal Circuit has had a tough time this year with the Supreme Court. In 2 of the 3 patent decisions rendered by the court during the 2011 term, the court unanimously reversed the Federal Circuit. Why does the Federal Circuit keep getting it so wrong?
Well, first, in the one case where they affirmed the Federal Circuit, it was also 9-0.
Right?
So apparently when they get it wrong, they get it really wrong. And when they get it right, they get it really right. I think it's kind of unfair to talk about the Federal Circuit in the sense of they're getting it wrong. The panel before us talked about, actually it was the dean, about the importance of IP to our society, to all of us. We see it constantly now. It's in the newspapers. It's in the press. Talk about Apple, Samsung. We in my company lost the biggest case ever. We got it reversed by the Federal Circuit. They got that one right. But that was over close to $2 billion judgment against us down in Texas. So there's a lot more interest. There's a lot more focus on the IP. That's why probably a lot of you are here. And therefore, there's more attention on the one appellate court that has to decide these cases. I look quickly at the stats for the Federal Circuit. They had over 838 some cases, out of which 300 or so are from the district courts in the 2011 term, and about 50 from the patent office. 3 of those cases went up. Obviously, when the Supreme Court is going to take a case from the appellate court, it's because it feels it needs to say something, and generally that's going to be a reversal, especially when you're not talking about conflicts of circuits. So I think they're getting a lot of attention. I think it deserves attention because of the importance to society, but I'm not sure that they are getting it totally wrong necessarily.
Right, and to dovetail with that, I think it's unfair to say they get it right or get it wrong, right? On the court itself, there's sometimes a split of decisions that's reviewed by the 3-judge panel, right? And if they don't take it en banc, then that decision goes up, assuming the Supremes take cert, right? So it's really unfair to say that the whole court gets it right or gets it wrong. You've got split panels all the time, and in fact, one of the cases I'm really interested in hearing about is something towards the end of the program, and that's regarding the safe harbor. And you get a split panel there in terms of when does the safe harbor apply? Is it pre or post-marketing activity, right? So, but to say that the court gets it right or gets it wrong, I think it's just a little bit too short in the analysis.
Do you think that the current focus on healthcare reform has any effect on the way that the Supreme Court views these kinds of cases?
I think they can certainly take that into account. I mean, it's no surprise as the pharmaceutical industry, the savings that the generics bring to the market. I think the last published data was over the last decade, there's been a saving of about $1 trillion, right, to the American public with respect to generic drugs. So the fact that plays into healthcare reform and the availability of generic medicines to the public at large, the court would be remiss to not take that into consideration.
I agree. I mean, I think you see it. Two of the cases this term had to do with healthcare, essentially, right? I mean, the court is like everybody else. They have families. They have their own expenses. They read the newspaper. They see the press. And so, yeah, I do think that their attention on IP and on the impact of IP, in particular on healthcare, is one of the things that's brought this to the attention of the Supreme Court.
In Novo's new and expanded use code, indicating that the drug's patent claims with the FDA, as I said earlier, doesn't review, effectively covered the use of the drug Caraco hoped to market. The fact was that the use code was changed after it became clear that Caraco was filing an ANDA to cover the non-patented uses. So it really appeared that this was a strategic move to stop Caraco's ANDA, because by expanding that use code, the FDA could not approve the ANDA because of the fact that the expanded use code now covered the unpatented methods that Caraco was seeking approval for. Were they really just playing fast and loose, or do you think that there was a real solid basis in the law anywhere to support what they were in fact trying to do?
You know, I smile at your question because I'm a little biased, as I'm sure Jose is on the other side as well.
Never.
Having spent 7 years leading the IP group of the world's second largest generic drug company, do I think they were playing fast and loose? Fast and loose may be a little bit too pejorative, but I definitely think that it was a strategic move on their part to do that. Because of the way that they framed the use code change, right? So take a step back and look at the bigger picture and on how use codes have played into Orange Book litigation and Hatch-Waxman litigation. Historically, all the use code was tracking a patent claim. The person who had to submit form 4542 or whatever it was would just copy the patent claim and submit it to FDA, and it would never be heard from again. There was no consequence. It was only when there's a little bit more sophistication in the statutory scheme that says, hey, wait a minute, there's actual real impact with these use codes. We can do something with them. If we draft such a code that prevents a carve-out, then a generic sponsor is not going to be able to get a skinny label and do an end around of our patents and thereby get to the market. So why don't they do it more often? Well, that's really because of an antitrust gut check, because they're going to face a lot of risk and a lot of exposure from third-party payors in terms of did they actually do something, illegal to prevent generic competition. And in this case, the reason why it happened, which I think this case has much ado about nothing, I mean, we can talk about that, but it's because of the action that FDA took. Now, you gave the syllabus of the case where the drug has 3 approved uses, and it does. It can be used by itself. It can be used with another drug, metformin combination, or another class of drugs called TZDs, right? And this particular patent happened to cover the use in combination with metformin, right? But what FDA did was, in looking at the indications for anti-diabetes drugs, it says it wasn't going to go with this long list of indications, instead shortened it to the treatment of type 2 diabetes mellitus, right? So Novo seized upon that opportunity to say, take that change in language from the label, and we're going to link it to this use code for this particular patent. Because now when the use code reads for the treatment of type 2 diabetes mellitus, well, you can't carve that out because that's the entire treatment of the product. To do so, you'd be effectively be saying that the product can't be used for anything because there'd be no uses in the label. So that's why we have a unique factual circumstance here, based on FDA action in order to change the use code to prevent the carve-outs to have this strategic decision. Because I don't think you're going to see another case like this with a use code like that because of the antitrust liability risk.
You won't hear this often, but I agree with Steve. When we had a chance to file an amici on this one, we passed. When the team presented the facts of the case, I said, this is a 1 in a million. I didn't think the Supreme Court was going to take cert on this, and when they did, I was surprised. I thought they had more important issues to decide. They keep refusing to take cert on reverse payments, which is an issue that both the generic and the pharma industry are very interested in, and you have splits in all the circuits about whether that's an antitrust violation. And yet this one, which is a 1 in a million case, they take. I have no idea why.
Well, could it possibly be what I said before, the ongoing pressure for healthcare reform that may have driven that decision?
Well, reverse payments have a bigger,
Well, I'm sorry.
it's a bigger factor in pressure. I'll put it on Jim Hirsch from Winston & Strawn, who was Caraco's attorney and is one of our attorneys at Abbott, not on the drug side, on his skills, because it really was amazing that they would take this. Like Steve said, the FDA told Novo to change its label, as it did to every other company on this class. And it collapsed 3 different indications into a broad indication. And the way I look at it is, there was a patent on Jose Rivera, there was a patent on Catherine Rivera, and there was a patent on Roman Rivera. My patent had expired, Catherine's patent had expired, and there was a patent on Roman Rivera. You could carve the Roman out and still sell a product on Jose and Catherine. What the FDA said is, hey, no, we're going to make it the Rivera family. And Caraco's argument was, wait a minute, even though you have a patent on one of the members of the family, it's unfair for you to be able to draft a use code to sort of claim that this patent actually does what the indication says. It does treat diabetes. It does it in the way that the indication claims. So I think it's 1 in a million, but I don't think Novo was playing fast and loose at all. And in fact, the fact that the Federal Circuit 2-1 went their way, and when they had the opportunity to rehear the case en banc, apparently 2 out of, 12 of them, only 2 of them were for the granting of the en banc petition, tells you that at least 10 or 11 judges at the Federal Circuit thought that there was nothing improper on what Novo did. I don't think, this is not, I looked at the briefs to see if Caraco argued that somehow Novo had tricked the FDA into changing the indication, but it was a class change. So Novo was not the impetus of the change. And I do agree.
I'm not sure I necessarily agree with that. Yes, the FDA did come to Novo and said, change your label. But they didn't require them to change the use code.
All right?
They just, the FDA did a beautiful job of teeing this up for Novo.
Right, but the use code reflects what the patent covers. But the fact of the matter is that that patent does cover the indication.
It does, yes.
It does. So what was improper of saying my patent does actually cover the one indication that the FDA has given us? My patent covers it. It may not cover it fully. There's lots of different ways to use this product, but the FDA told us to collapse it, and my patent now covers that indication. That's what they did.
Because then you're relying on the linkage between the use code and what the FDA did with respect to the label.
You're supposed to say what your patent does. In a broad sense, the patent does exactly what they said it does.
I think in that instance, I would, if I'm in Caraco's shoes, and to use your example, I'd say, no way, Jose. Is that going to fly, right? So it's not going to do it that way. So and that's why I said I think it was a little bit too pejorative to say they were playing fast and loose. I think they took a strategic decision and the opportunity to do that. But I completely agree with Jose. That's a unique set of circumstances. We got a 1 in a million shot here with the case.
And in fact, I don't think Caraco has been approved. The indication has changed. It is a broad indication. And I'm assuming they're battling out the infringement question, because they will infringe.
Yeah, what the press hasn't picked up on are some of the other idiosyncrasies of this particular case. And one is some of the citizen petition work that was done with respect to this particular patent, in fact, because it doesn't claim just method claims, it also has a product claim. And under FDA rules, you can't file a Section 8 as to a product claim. So you're not going to file just a Section 8 across the board as to this particular patent. You've got to file a paragraph 4. So there's still the paragraph 4 at issue and this patent. In fact, the district court in Michigan found it invalid as obvious and unenforceable due to inequitable conduct, right? And so that particular appeal was stayed by the Federal Circuit pending the sole cert business, and should, in fact, it was picked up back by the Federal Circuit. As to that particular appeal, I think that one's still sitting, but as to the use code part of it, there was a decision that came out in July that actually ordered Novo to change its use code, and in fact did in the middle of August, going back to what it originally had been. Right? So if we went back to those state of facts, then a carve-out is possible with respect to that particular patent, but as to less than all the claims in the patent, you're still going to have to file a paragraph 4, and there's still ongoing paragraph 4 litigation between Novo and Caraco, and in fact between Novo and my former company Sandoz. And then yet another esoteric issue in this particular case is there a forfeiture of the first filer? And I know I'm going off track a bit here, but the reason why it's important is because we're talking about these definitions of any or an method or a use. And it's the same kind of issue with the petition saying they forfeit because did they get their approval within 30 months? And that issue is going to resolve on the construction or the interpretation of the one word, within. What does that mean? Within 30 months.
So what Steve is referring to, I'm not a patent lawyer, but I do this for a living, is that the name of the game for a generic is to be the first filer of this paragraph 4 and challenge the innovator company's patents. If you do that and you do that successfully, the first generic gets 180 days, 6 months of exclusivity, which means they have no competition from any other generic, and the FDA is prohibited from approving a second generic. If you do not, however, get approved within the first 30 months after you file the ANDA, the abbreviated new drug application, then you forfeit. In most cases, there are some exceptions. And that sounds what is happening here, where Caraco forfeited because they didn't get approved on time. So now it's a free-for-all. Every generic could potentially get approved in whatever order the FDA gets to them and take the market.
When we get into the motivations of Novo and how and why they did this, it's really an interesting aside to this case because that's not really what this case was about. It was not about whether or not Novo improperly changed their use code. At the end of the day, it's a more straightforward, can Caraco file a counterclaim against Novo to force them or to get an injunction forcing them to delete or to change their use code. I wonder, Steve, if you could tell us what you think the real nub of this was and how did the court get there?
Well, the real nub of it is can they get to the skinny label, right? Can they carve out the patented use from their label? Because that's classic I'm getting ahead of myself. That's a classic Section 8 case, right? You got a patented use and an unpatented use, and you're the generic and you want to file your application, well, you'll carve out the patented use and say, no, I'm going to mark it for the unpatented use, right? And there I'm going to get the skinny label, I'm going to only have the unpatented use in my label, but therein lies the problem. We've got an inherent conflict with the drug system that we have in the United States, and that's with the automatic substitution laws. So it doesn't matter if the generic's got unpatented indication, right? When the doctor writes its script, most doctors, if you talk to them, they're not going to even know the generic name if you're talking to them. They don't know the generic names of the drugs. They know the brand name. Right, so when you write a script, they write the brand name on the script pad, right? You take that script, you go to the pharmacy, and what do you get? Right? Unless your doctor writes it dispense as written or some other instructions, 95% of the time, whatever the percentage is, very high percentage, if not all, most of the time, you're going to get the generic, right? And the generic's going to come with that label, right? And it may or may not have that patented use on that label. So even if you're successful with your Section 8 and getting that use carved out of your label, you're still going to face an inducement claim because brand companies, like Mr. Rivera's client and all the other brand companies out there, you're going to have these inducement claims saying, even if you've got it out there, you know you're going to be substituted, you know it's going to be marketed, you know it's going to be used in the market for the uses that you've carved out, so that you're going to have an inducement claim. So I know it's a long answer to your question. What do I think the real rub of it is? I think it's leading into this issue, skinny labels, yes, what's it mean? But then how does that interplay with induced infringement and the substitution system we have in the United States?
I don't see the generic stopping in fear of inducement claims once they've carved out. They will launch as soon as they can, even if they carved out every other indication but one. And within a couple of weeks, within a month, the generic company will have captured over 80% of the market of the innovator. And that will be it'll include the uses that are carved out and the uses that are in. Like Steve said, the generic is just going to sell and the pharmacy is going to replace. And they're not going to ask the doctor or the patient, are you going to use this for an infringing use or not? And if you're using for an infringing use, I will not sell it to you. It doesn't happen. So from our perspective, from the innovator company side, once one method goes, you essentially, it all goes. The previous panel talked about, the court and being careful about taking property rights, et cetera. This is a classic example of Congress, and with the help of the courts, taking, we believe, the innovator's property right. It costs a lot of money to develop these other indications. And frankly, as somebody who sits in the discussions within our company as to whether we should make investments on either new products or new indications, one of the first questions we ask is, when is the first method going to go off patent? Because once that first method goes off patent, there makes no sense for us if it's too early to make the investment. So there's a lot of products out there that perhaps would have more uses, more benefits that could be put in clinical trials with the development of science, some old compounds, but nobody is going to ever touch them in the innovative side, and that means nobody, unless the government decides to do it, and they won't, they can't. Nobody's going to touch them, and they're going to sit there on a shelf because the compound patent is gone, maybe the first method patent is gone, and then that's it. You're never going to touch it again. And so there is a cost. There's a savings on the generic side, that is true. But there's also a massive cost, I think, and I think the innovative side thinks, the fact that a lot of good things are never going to be invested in because of this system.
Well, in addressing the off-label use issue, the law was vague. Do you think Congress had any notion when they were working through this legislation that off-label use would be an issue here, therefore supporting the notion that Novo put forth that any approved use would exclude the paragraph 8 certification?
If you're asking me, I don't think Congress cares about off-label use if it's the generic product, because they're relying on the work that the innovative company did to get the method patents and do the clinicals, et cetera, to support that indication. I think Congress knows that the generic products will be sold off-label. Now, you can sell off-label.
You're using the term off-label to mean carved out.
Carved out.
Right.
But from a generic,
off-label's got a different connotation.
Right, and I was going to get to that. I mean, the generic has, let's say, one indication where the brand has two indications. And your point is there's an off-label sale because the generic will be used for the second indication that's still patented. It technically, off-label sale in our world means that you went and promoted something and you made representations to a physician or a patient that it works for something that you haven't been approved for. The generics don't do that. The generics simply sell to the pharmacy, and the pharmacy does the substitution. So they don't do off-label sale in the typical sense of the word. But the seed of your question is, did Congress care? No, I mean, I think Congress said it's a copy. It's essentially the same active ingredient, essentially the same formulation, sometimes identical, sometimes not, and you can sell it, and save us some money. I don't know if you have a different impression.
Look, I think to use your phrase, I see the question or the issue is going to be, as I see this case, dovetailing back to inducement, right? And now we've got this decision, the McKesson case, right? This inducement-only case, right? It just came out, I don't know, a week or so ago, right? You can have inducement infringement without direct infringement, whatever that means, right? So now with respect to inducement claims in the pharmaceutical realm, where you've got to show a specific intent to infringe when as we discussed, right, the product gets just substituted at the pharmacy, are we now just collapsing that and removing the specific intent requirement from DSU medical and now really turning it into what appears to be a strict liability statute? Because you're not really looking at the intent. You say, because you could have filed a paragraph 3. That's what some of the cases say. If you didn't want the product to be substituted for use, you could have filed a paragraph 3. Well, no, there's still a right here to be able to promote or sell the product for the unpatented use, and you are overreaching with your patent to try and ensnare that through these inducement claims. So it's going to be an area very fertile for litigation going forward, and that's where this case starts.
Well, I think some of these things are very factual. Sometimes the first method is the method that has maybe 5% of the sales, and it's the patented method that has 95% of the sales. So the generics position is like, well, as long as I sell it and I have nothing to do with the substitution, but they know what the market they're going for. I mean, when a generic puts down its sort of financial plans, I am sure that they don't say, well, we're only going to count with the revenues from the carved out indications. They're looking at the entire thing. And so to the extent that they infringe, obviously from our standpoint, from an innovative standpoint, they should pay the price of infringement.
So the way around that then is to forecast it and discount a particular market segment?
Just send us a check.
Everything you substitute above that is just, you beat your numbers, you beat your target.
Or
right?
actually invent something yourselves.
Right.
That's an easy solution.
Wow. So I think it can really work with Justice Sotomayor's concurring opinion, right? Because she talks about it needs a fix, right? But I don't think the fix that's needed here is with respect to use codes. I don't think you're going to see the use code issue really ever again if you're going to see it.
I agree.
Maybe once, if that, right? The issue is really going to be on inducement, right? And you can see Jose and I go back and forth, and we've been on across the aisle on a number of cases and working these cases from these different perspectives. And it's going to continue that way with respect to these carve-out issues. So I agree with Justice Sotomayor that a fix is needed and needs to be addressed by Congress, but it's not with respect to use codes.
What is the fix?
I don't have the fix, right? Because it involves a lot of issues of larger public policy issues that go outside just the realm of patent infringement. You're talking about, as I mentioned earlier in the talk, saving $1 trillion over the last decade to American consumers. You're not just going to completely eradicate that because you don't want to honor somebody's property right in their patent, right? It's not a simple answer to the question. So it's something that requires deep thinking and a lot of other people to really flesh that out on what the fix might be.
They got, I think Steve is right. I mean, one of the some thoughts that have been battered around is, for example, should we just say an innovative product is going to have X amount of life? That's it. Sort of, like in the biologics world. 12 years, that's it. Now, in the biologics world, you can still assert patents, et cetera, but some people have said, well, why don't we just say 12 years and patents are irrelevant to the innovator, right? You just get your 12 years, you can milk that baby as much as you can over 12 years, and then you're done.
7 years, right? 7 years, right?
Right, well, let's do 15. And so those are the type of things. I completely agree with Steve when I saw your question. I said, no way Congress should be spending any time on this. They have bigger issues, more important issues on this. We're not going to see this again. And there's the FTC also. I mean, if you do abuse the use code, the FTC will be on you.
So you don't think there is ever going to be the possibility that these use codes will be reviewed by somebody with expertise in patent law?
I hope
Down
not.
the road?
I hope they're paying.
Not in the judiciary, right? The only
No. I mean at the administrative agency level.
In fact, the only other instance I've ever seen with this use code evolution is with a product called Scalaxin. Right? It was sold by King Pharma, now part of Pfizer. And if you follow their life cycle on this particular product, you go back and look at the Orange Book codes, they were starting to get patents on metabolic data, right? Patents directed to the drug is metabolized by a certain cytochrome in the liver, and very specific things as to metabolism of the patent. And so when they were getting this IP, that's what the use code would state, right? Using metaxalone and having this particular metabolism, blah, 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 blah. The use code was 3 lines long, right? Then with this Repagline, what was happening, as King was getting more and more of these patents, the use code would shorten to using metaxalone. Okay? Well, how are you going to carve out using metaxalone out of your label? You'd have no label. So that's really the only other instance I've seen where this has gone on with the evolution of the use code that way, and it never came to light because it was in a trial with my last corporation. We validated the patents through a jury trial. So it never ended up coming out that way, but that's the only instance I've ever seen with this use code that way.
And I've been at Abbott 16 years, and we've been accused of a lot of things. This is not one of those things that we've ever been accused, so it's extremely rare. I agree with Steve. They have other issues they need to be paying attention to.
Well, just as a follow-up, and I think you mentioned this, this case did go back to the district court, and the district court issued an injunction commanding Novo to go back to their original use code. They, of course, appealed that. It went up to the Federal Circuit.
Right.
And the Federal Circuit basically held in that case that the court can't tell you what to put on that label.
Right.
That's your job.
Right.
Just give them a better label.
Right.
And that's where these issues stand today.
Right, and that was even a 2-to-1 decision. On
Yeah,
whether they
2-to-1.
could tell them what to put back in the use code.
Yeah.
Right? And then they, in fact, have since changed their use code.
Okay, well, we started a little bit early, but I'd like to save a few minutes for some questions.
Not a doctor, but thank you.
So, although for the whole panel as well. So you mentioned just in passing the idea that the government might be interested in doing research on new uses if in fact these patents end up being ineffective because of off-label uses. And so there is a new NIH institute called NCATS that's specifically devoted to repurposing old drugs for new uses. Do you think that pharmaceutical companies will be interested in collaborating with government on finding new uses for old drugs?
We are participating, and we've donated some of our library of compounds to NIH. The issue that I'm talking about is, you can find the drugs, but it's a very expensive, and it takes a lot of people and a lot of effort to develop drugs. And I do think that NIH seems to go down that program. We've donated some of our libraries so that they can get going. I just don't know how productive a government agency will be in developing drugs.
Well, this isn't development of new drugs, it's development of new uses for existing drugs, right? So it's a little bit distinct.
I thought they were taking all compounds, not necessarily that have been sold, but do you know, Steve?
Yeah, I understood it was for new uses for old compounds.
Okay.
Right.
Okay.
Yeah, I mean, and so the question is, is there a way to incentivize people to just find new uses that is not patent-based? And one alternative.
There are companies in the private sector that are actually trying to do that now. One of them was a company that was started up here in Northbrook, I think called Ovation. And their whole purpose was to do just that. And they went to companies like Abbott and a variety of companies around the United States
and said, look, we want to take these old compounds and, first of all, use them for the original uses, and then did R&D for additional indications, and they've actually been quite successful doing that. But I think there may be only one or two companies that have actually taken that on.
I mean, your only exclusivities are going to be patent or regulatory, and if the product was already approved, then you will get 3 years. And the generic can challenge you at any point within those 3 years. I don't know what their business model is.
Yeah, that's a tough model because of the substitution, right? So even if you do the studies, get your data exclusivity, generic's just going to carve it out.
Unless they're going to Europe or so, but even in Europe, I don't think they're going to get the entire time.
And I think rather than perhaps going to Europe, just going back to basic research in an entirely different area, like that drug that was initially used, I think, was it heart control, and then ended up becoming Rogaine. But that kind of work, I think, isn't going to get done by industry and by private industry. That kind of work through perhaps the facilities of the NIH is going to get done more at academic institutions. So it just starts the cycle all over again.
But academic institutions, I agree. I mean, that's where the research will be done. But ultimately, you have to have a manufacturing plant. You have to get approved. You have to be validated. And there has to be an incentive for the companies to dedicate a plant to manufacture this. And 3 years isn't going to do it. I mean, the perils on the other side, dealing with the FDA, getting it approved, having FDA inspections, off-label accusations, et cetera, and then facing the generics within 3 years, there's no money in that. So maybe Bill Gates will pay for it.
That's somewhat similar to trying to get drug companies to develop orphan drugs, right? So they give them the 7 years data exclusivity, right? For the treat populations, I think the number is 200,000, whatever, at least it was before. I don't know what it is currently, but trying to incentivize companies to do that, develop drugs for those populations.
In the concurrence that Justice Sotomayor wrote, she expressed some pretty significant concerns about the guidance FDA provides for how these codes get drafted, and I think each of you have picked up on that in your comments as well. Do any of the panelists anticipate any change at FDA in response to that might provide some greater clarity as to what these drafts actually ought to look like?
Jose, why don't you start?
I don't think so.
Guidance from FDA? No, not at all, right? Not in that particular realm. I mean, they do a lot of great work with their guidance documents and try to help the public on how to work applications through the agency. But we're talking about a very short form here with the one.
She said it was 240 characters, right?
Yeah.
So
Yeah, you've got to essentially tweet your, your indication there, what it is supposed to be, right? So I don't think you're going to see any action from FDA on that. They don't want to touch patents with a 10-foot pole.
Plus, before, maybe there was an incentive, but now with the Supreme Court decision, knowing that you're going to face a counterclaim, Steve pointed out, you're going to get the FTC knocking on your door. I mean, what's in it? I mean, I think people are just going to stick to what 99.999% of everybody has been doing, which is to stick to your patent and just describe it and move on.
That's why they have the FTC shield in this case. That's why it's so unique. They could hide behind FDA. Right? See, FDA told us to change the indication. Well, they didn't tell us to change the use code. No, we could, because that's what they directed us to do. So that's why this case is very unique.
So you guys have mentioned that this case you think is much less significant than other issues like reverse payments. Any thoughts on if the Supreme Court is going to grant cert in a reverse payment case, and if how the justices lined up and how they wrote in this case would inform how they would view reverse payments?
I keep thinking they will grant cert. Now we have what, a split of 2 to 3, 2-4?
All the circuits, right?
Yeah.
Mm-hmm.
And with the FTC clamoring for it. I don't know, because it's interesting, because on reverse payments, it will be the government and plaintiff lawyers against both pharma and innovators. I think both of us believe that there is, first of all, it's not anti-competitive, as long as you stay within the boundaries of the patent. and number two, that it actually is valuable to be able to settle. And both of us get certainty as to what's going to happen. You know, most of these reverse payment cases, the generic will reach the market before the patents expire. The alternative is to go to litigation to the end, and if the brand wins, then the public will not have the generic out selling at a cheaper price.
I think you do get a little flavor of where this might go in reverse payments because Kagan consistently, throughout her opinion, refers to the fact that this legislation was enacted to get generic drugs into the hands of the consumer as quickly as possible. And if reverse payments, if that is what her thought is on the overall statutory scheme, I think she's going to be pretty hard on reverse payments.
Well, then she may end up pushing.
And the question that gets factored into the analysis, at least in some of the circuit decisions, is the relative strength of the patent. Well, who decides that? Right? Are we talking about a patent that's being decided in the Eastern District of Texas? Or are you talking about a patent that's being decided in Michigan? Right? So it depends on where your court's at, right? So who decides this relative strength? It's a subjective question.
And the FTC definitely doesn't want to have that litigation.
Don't you want to be in Philadelphia or Delaware with those cases?
As I said, I think the other interesting issue is the safe harbor, right? So the Clausen case is up for cert, right? And then the enoxaparin decision that came out that said, in terms of if FDA requires you to keep the information, right? Well, that's going to satisfy the submission prong of the safe harbor, which I don't understand that because anything in drug development or marketing, you have to keep the documents. So what, as to a drug, is not going to be part of the submission. And it doesn't matter if it's pre or post marketing, it's within the safe harbor. So now the safe harbor, under that rubric, has become the safe ocean. Because as to pharmaceuticals, you're going to have to keep all your testing data. And why limit to just testing patents, right? Because the FDA requires it. They require a particular compound. They require, all these other things in their rules and regulations. So it's FDA required, and you got to keep it. So taken to its logical extreme, under that enoxaparin decision, everything is in the safe harbor.
Frankly, from an FDA standpoint, you really can't destroy much. I mean, every batch, every test, every validation, that all has to be kept. So Steve is absolutely right. It's just extended the exemption forever. I mean, the safe harbor. And then you as a generic, I mean, or as the innovator, well, I guess it'll be a generic in this case.
I'm on the outside now, Jose.
Yeah, we'll try to just get the FDA to require you to do something in addition so that you can just be protected.
Right.
So it's a bad decision.
Good question, Dave.
Any other questions? Okay, I'd like to thank Jose and Steve for helping us discuss the 1 in a million case. Thanks, Dave.